welcome to 30 Years, 30 Cases, a series of video podcasts launched by the Academy of European Law ERA to mark its 30th anniversary. My name is Nataša Vujnović. I'm a course director in the business law section of the ERA. The podcast series addressed landmark cases of the European Court of Justice for each of ERA's 30 years of existence. This podcast is dedicated to the judgment which dates back to 16 June 2015. It is the case C-62/14, widely known as the Gauweiler case. This case will be revisited, and its importance as a landmark judgment of the Court of Justice in the field of the law of the Economic and Monetary Union will be addressed by our guest expert, Professor Peter Christian Müller-Graff. Professor Müller-Graff is a senior professor of civil law, commercial, corporate and business law, European law and comparative law, as well as the honorary Jean Monnet professor at the Heidelberg University. He pursued his studies at the universities of Göttingen, Berlin, Tübingen and Cornell, New York, passed his legal state exams in Baden-Württemberg, and earned his doctorate and habilitation at Tübingen University. Prior to his appointment at Heidelberg University in 1994, he was professor of law at the universities of Cologne and Trier. His main research interests include German and European private and business law, European constitutional and internal market law, and law of the European Union. He is the author and editor of some 700 books and articles. Professor Müller-Graff is counsel to national, international, and foreign public authorities and has represented the Federal Republic of Germany before the European Court of Justice. He is also a member of the Board of Trustees here at ERA. Professor Müller-Graff, it is a pleasure to have you elaborate on the Gauweiler case. Why was this preliminary ruling of the European Court of Justice so important?
The preliminary ruling in case C-62/14, so-called Gauweiler case, was important because it dealt with two highly unclear and controversial questions of primary, hence constitutional, union law of the Economic and Monetary Union. First question, the conditions and limits of the European system of central banks, monetary policy competence, Article 127 of the Functioning Treaty, and second, the ramifications of the prohibition for the European Central Bank, the ECB, and national central banks to purchase directly debt instruments of member states, Article 123 Functioning Treaty, the ramifications on purchasing them, those debt instruments, on so-called secondary markets, for example from commercial banks that had initially bought those debt instruments of member states. The importance of this judgment becomes apparent from its triggering event and from the Court of Justice's answer to the referred questions. What had happened? In 2012, the budget deficits of several Euro states, presumably as a consequence of their failure to fulfill their primary law obligation to avoid excessive government deficits, these budget deficits culminated in the problem of those states of finding creditors at the capital market for buying the sovereign bonds at portable interest rates or at all. And hence the danger became imminent that those states could be forced to break away from the single currency and reintroduce their own currency. In that situation, the president of the ECB announced that the ECB would, and I quote, do everything what it takes, quotation ends, for guaranteeing the so-called integrity of the Eurozone. On September 6, the Governing Council of the ECB approved a program called Outright Monetary Transactions, abbreviated OMT, concerning purchases in the, and I quote, secondary sovereign bond markets with the aim at safeguarding an appropriate monetary policy transmission and the singleness of the monetary policy, quotation end. The main features of this program were characterized by several headwords. Among them, the most important, first, conditionality. What does it mean? In the sense of the attachment of the respective state to an appropriate stabilization program of the European Financial Stability Facility at that time, or the European Stability Mechanism. Second, coverage. Coverage in the sense of the eligible bonds and an unlimited quantitative volume. And third, creditor treatment in the sense of the same treatment of the ECB as other creditors. Why did these OMT decisions lead to a preliminary reference procedure before the Court of Justice? The OMT decisions provoked sharp criticism of several German economists, constitutional law scholars, political groups, and individuals. They argued that the OMT program was, first, in fact, a monetary budget financing mechanism in favor of certain needy Eurostates, hence violating Article 123. And second, these measures, this OMT program, amounted, this was their argument, to an economic policy action beyond the Article 127 competence of the European system of central banks, hence a so-called ultra-virus action infringing the principle of conferral, basic principle, Article 5, paragraph 2, Treaty on European Union. Eventually, several groups of individuals brought various constitutional complaints before the German Federal Constitutional Court, the Bundesverfassungsgericht, concerning the alleged failure of the German government, Bundesregierung, and the Bundestag, German parliament, to act against the alleged infringements of union law by the OMT decisions, thereby breaching the principle of democracy entrenched in the German basic law and impairing German national identity. The Bundesverfassungsgericht now stated that if the OMT decisions exceeded the mandate of the ECB or infringed Article 123, it would have to uphold those various constitutional actions. Hence, it referred to the Court of Justice a question of whether the OMT decision was incompatible with primary law, in particular with Article 127. Quote, because it exceeds the monetary policy mandate of the ECB and encroaches upon the competence of the member states, quotation end. The Bundesverfassungsgericht submitted in particular 4 aspects of concern in regard to the OMT decision: its conditionality, its selectivity, its parallelism to the assistance EFS or ESM programs, and its possible circumvention of those programs. Concerning the possible incompatibility of the OMT decision with Article 123, the Bundesverfassungsgericht unfolded 5 aspects. First, its unlimited volume. Second, its impact on primary market prices. Why? Due to the lack of a time gap between the issue of the bonds on the primary market and the purchase on the secondary market, and also due to the encouragement for private investors to purchase newly issued bonds of those member states. Third, its interference with market logic. Why? Due to holding all purchased bonds to maturity. Fourth, its default risk. Why? Due to the lack of any specific requirement for the credit standing of the bonds of those member states. And fifth, the danger of a debt cut. Which was the answer of the Court of Justice? In short, the relevant union law, quote, must be interpreted as permitting the ESCB, the European System of Central Banks, to adopt a program for the purchase of government bonds on secondary markets, such as the OMT program. Quotation ends.
How did it contribute to the development of the European economic and monetary law?
The ruling contributed to the development of the law of the Economic and Monetary Union through the interpretation of the two mentioned central primary law provisions in this context. First, the powers of the ESCB, Article 127 Functioning Treaty, and second, the consequences of the prohibition of directly purchasing government bonds by the ESCB, Article 123, on the purchase of such bonds on the secondary markets. Concerning the powers of the ESCB, several normative statements of the ruling are important. I name 5. First, the judgment emphasizes the principle of conferral and hence declares the acts of the ESCB subject to judicial review by the Court of Justice. Hence, no legally unlimited scope for political maneuver. Second, the ruling confirms the wording of Article 127 that the primary objective of the Union's monetary policy is to maintain price stability, and that, without prejudice to that objective, the ESCB is to support the general economic policies of the Union. Third, the ruling refers for the delimitation of monetary policy from economic policy, which is in the competence of the member states. It refers for this delimitation principally to the objectives of the respective measure and also to the employed instruments, thereby assessing the OMT in view of the objectives to safeguard both an appropriate so-called monetary policy transmission and the singleness of monetary policy. And in view of the provided instruments as falling within the area of monetary policy. Fourth, it holds that a monetary policy measure cannot be treated as equivalent to an economic policy measure merely because it might have indirect effects on the stability of the euro. And fifth, it confirms the applicability of the principle of proportionality. This means suitability, necessity, and appropriateness to a bond buying program. but allows the ESCB in that context, and I quote, a broad discretion, end of quotation, also subject of a judicial review of compliance with certain procedural guarantees, such as careful and impartial examination of all relevant elements and giving an adequate statement of the reasons for its decisions. Thereby, for the OMT program, in result, denying a manifest error of the ESCB in assessing the economic situation and confirming the program's suitability, necessity, and appropriateness. Concerning Article 123, the Court of Justice developed the important rule that, I quote, the ESCB does not have the authority to purchase government bonds on secondary markets under conditions which would, in practice, mean that its action has an effect equivalent to that of a direct purchase of government bonds from the public authorities and bodies of the member states, thereby undermining the effectiveness of the prohibition of Article 123. Quotation ends. The Court of Justice concluded that the OMT program, I quote, does not lessen the impetus of the member states concerned to follow a sound budgetary policy. Quotation ends.
Is the judgment still relevant today?
Yes, the judgment is still relevant today. In which way? In three ways. First, the interpretations of Articles 123 and 127 in the judgment have served as the decisive normative reference points for the Court of Justice subsequent preliminary ruling December 2018 on the subsequent so-called public sector purchase program of the ECB. Second, the ECB understandably relies on the Court of Justice interpretation in pursuing its monetary policy. And third, the Court of Justice interpretation of the powers of the ESCB did not settle the underlying general political conflict over the ESCB's public sector purchase policy approach and its competences. On the contrary, the Court of Justice granting of a wide discretion to the ECB was already criticized by the subsequent final OMT judgment of the Bundesverfassungsgericht in June 2016 with the words, and I quote, generously accepting as fact proclaimed objectives of EU institutions, while at the same time granting them wide margins of assessment and considerably decreasing the intensity of judicial review, is capable of enabling institutions, bodies, offices, and agencies of the EU to decide autonomously upon the scope of competences that the member states have transferred to them. Such an understanding of competences does not sufficiently take into account the constitutional dimensions of the principle of conferral. Quotation ends. Eventually, the Court of Justice methodological approach came under the frontal attack of the Bundesverfassungsgericht in the later judgment of May 2020 on the mentioned public sector purchase program, the PSPP, of the European Central Bank, in which the FCC, the Bundesverfassungsgericht, held the Court of Justice as having acted ultra vires. Quote, the standard of review applied by the Court of Justice fails to give effect to the function of the principle of conferral as a key determinant in the division of competences and to the consequences this entails in terms of methodology for the review as to whether that principle is observed. Quotation ends. This conflict lingers on and may again explode in the future.
What have been the effects of the judgment?
The effects of the judgment, you are asking, were twofold. On the one hand, the Bundesverfassungsgericht, in result, despite its concerns, followed the preliminary ruling in the OMT case and even found itself confirmed in its restrictive normative approach to purchases of government bonds, also as seen not without uttering concerns. On the other hand, as just mentioned, the preliminary ruling did not settle the underlying general political conflict over the ESCB's public sector bonds purchase policy approach and the inherent competence question. As a consequence, the concerns ignited a new procedure before the Bundesverfassungsgericht, triggered by the adoption of the already mentioned decision of the ECB of March 2015 on a secondary markets public sector asset purchase program, the PSPP. And this led in July 2017 to a second preliminary reference of the Bundesverfassungsgericht, this time asking of whether now the PSPP was infringing the mentioned articles 123 and 127. And this again led to a new ruling of the Court of Justice in which it confirmed its interpretation of those articles and found that the consideration of the referred questions had, I quote, disclosed no factor of such a kind as to affect the validity of the decision 2015/774 of the ECB. Quotation ends. However, this time the Bundesverfassungsgericht did not follow the assessment of the Court of Justice, but held first its ruling as mentioned as acting ultra vires. The Court of Justice acting ultra vires. Ultra vires, which virus, the power of Article 19 Treaty on European Union. And it held second, the ECB's decision as exceeding the monetary policy mandate of the ECB deriving from Article 127 due to a lack of assessing the proportionality in relation to the effects on economic policy, and declared also the ECB's actions as a ultra-virus act.
What developments have there been in the case law since the judgment?
As already seen, the Gauweiler ruling did not settle the underlying general political conflict over the ECB's public sector bonds purchase policy approach and the inherent competence questions, nor did it solve the competence problem of the appropriate standard of judicial review in terms of criteria and density applied by the Court of Justice towards the European Central Bank. It has to be added, the same is true for the subsequent Weiss ruling. But the explosive reaction of the Bundesverfassungsgericht to that judgment was an obvious outbreak from the primary judicial procedural law as well as from the primacy of union law. Hence, the reaction of the Bundesverfassungsgericht in the Weiss case, May 2020, was a clear infringement of union law as it was correctly assessed by the European Commission and as it was also admitted incidentally by the German government in the infringement procedure. The Bundesverfassungsgericht, there should be no doubt, was under the union law obligation either to respect the Court of Justice ruling or to initiate a new reference procedure concerning the interpretation of the mandate of the Court of Justice, Article 19, and the role of the principle of proportionality in Article 127 in conjunction with Article 5, paragraph 4, Treaty on European Union. Having said this, however, the Bundesverfassungsgericht has a point in terms of substance. The review radius and review density of the Court of Justice towards the ECB and the published depths of reasoning of the Court of Justice are, in my opinion, not beyond any doubt, for two reasons. First, the reasoning of actions of the ECB requires comprehensible explanations, and this can hardly be achieved if the Court of Justice is satisfied by abstract, expertocratic, and hence potentially hiding pronouncements of the ECB, such as, I quote, appropriate monetary policy transmission, quotation ends, for reasoning a public sector bonds purchase program. One may well ask, how is this precisely connected? One would like to have a deeper explanation, a clearer explanation of this. Also, it has to be kept in mind that the requirement of extended scrutiny should not overturn and cannot overturn the wide discretion in decisions in complex technical matters of monetary policy. And then there is a second point, I said not beyond any doubt. Second point, the rule of law, Article 2, Treaty on European Union, requires that the Court of Justice reasons its rulings also on actions of the European Central Bank in a comprehensible language. Also, this can be hardly achieved by simply referring to abstract, expertocratic pronouncements of the ECB.
Which more recent judgments of the court are worth analyzing?
4 more recent judgments on the subject are worth analyzing. First, the PSPP referral of the Bundesverfassungsgericht of July 18, 2017. Then second, the PSPP preliminary ruling of the Court of Justice, case C-493/17. Third, the PSPP judgment of the Bundesverfassungsgericht after this preliminary ruling, May 5th, 2020, this judicial explosion. And then, fourth, the concluding PSPP order of the Bundesverfassungsgericht of April 29th, 2021.
In conclusion, what can be learned from this case?
Well, a threefold lesson can be learned from the Gauweiler ruling. First, that actions of the ESCB are not beyond the review competence of the Court of Justice concerning the questions of competence and proportionality. But that second, the next lesson to be learned, that the Court of Justice respects the final substantive responsibility, discretion and competence of the ESCB in the assessment of complex monetary policy options, I think for good reasons. And then third lesson to be learned, that the reasoning of the Court of Justice and as a prerequisite, the review questions posed to the European Central Bank for comprehensively explaining the measures should be intensified, widened and deepened, thereby perhaps raising its persuasive authority in this very sensitive area of competence and monetary policy.